By the state of North Carolina.
And what is your job? What do you do?
I'm the executive director. That means that I head up the staff for the commission, do all the administrative things. I've currently been dealing with hiring, budget, our bylaws, and then we'll be investigating cases, presenting them before a commission. If the commission passes, then they'll go to a 3-judge panel. These are post-conviction innocence cases. Someone's already been convicted. They're claiming innocence. There's some new evidence that the jury did not hear or a judge did not hear in a motion for appropriate relief. We investigate it. If there is merit, well, more than merit, if it's clear and convincing, then it can go forward.
And where were you employed prior to that?
I was an assistant district attorney in Durham County.
For how long?
For over 3 years. I was hired by Jim Harden.
You know Mike Nifong?
Yes, I was hired by Jim Harden, and then I was still there when Mike Nifong took over, and I remained there until just April of this year.
And do you know Mike's reputation in the community for being truthful?
I do. He has
What is it?
an excellent reputation for honesty and truthfulness in the community.
And you know what his habit is in terms of providing open file discovery?
I do. Mike was always, I think the common phrase is country before country was cool, but Mike was open file discovery from day one, and this was 25 years before we were required to do open file discovery. And when I came into the DA's office, that was at the time that the law was changing, and we were moving into open file discovery, but Mike had been giving open file discovery for his entire career, and we would discuss it in staff meetings rather extensively. What did it include, what did it not include? And Mike would always say, and at this time he was chief assistant district attorney, that was before he was DA, I don't even understand why we're debating this. If you have it, you give it. You just give everything. That's what open file is. And so I think it's very clear. That's what he's always done, and I've always admired that.
Did you ever have conversations with him involving the head DA's responsibility when it came to prosecuting certain cases?
I did. I actually had a couple of conversations with Mike about this. The first time that I talked to him about it was when he was still chief assistant district attorney and Jim Harden was the district attorney, and I was a rather new assistant district attorney in the office, and Mike was working he was the supervisor of traffic court, as I think he's testified here, and I was chatting with him at one point about the Peterson case, the Michael Peterson case that happened in Durham, and it happened right before I came in. I was hired, almost as soon as it was over and started. I was kind of curious, and I asked Mike his opinion of why he thought that Jim Harden, who's a judge now, but at that time was the head DA, personally prosecuted that case, along with some...
It is beyond the scope of character, but there was questions raised of Mr. Nifong about why he would take the Duke lacrosse case. This is substantive evidence. This is not character evidence. This goes straight to the point of what they're making allegations. The only reason he takes the Duke lacrosse case is for his election, and I believe this evidence would be relevant on that point. And that she is a fact witness as well as a character witness.
Okay.
They put that in issue, so I believe she...
It's just a surprise issue.
All right, I understand. Yeah, we're not talking about character. This is for some other purpose.
She's got some substantive points. We haven't always filled in all the substantive points.
I understand. Okay, I'll allow that.
Let me just recall where I was. I was asking Mike why he thought that Jim Harden chose to personally prosecute that case, and Mike told me that he felt that, and he agreed that this is how Jim Harden felt, and Mike specifically said, and I agree with this, that it is the duty and the responsibility of the chief district attorney, the head district attorney in the jurisdiction, to prosecute some cases that really embroil the whole community, cases that really involve the community, bring upheaval that people are really concerned about. They need to have the confidence to know that their chief is taking that case and handling that case personally. And so that was what he told me about the Peterson case. And then when Mike became district attorney, we all knew that that was the continuing theory. That had been Jim Harden's theory. That was also Mike's theory as well. And before the Duke lacrosse case ever came up, there was a case in Durham, and it's an unsolved case still, where there was lacrosse burnings in Durham. I think there were 3 of them. And that was really involving the community in the same way. People were really upset about it, really concerned about it. And Mike said at a staff meeting, if they catch who did those, the cross burnings, I would personally take that case. And he was letting us know, we were talking about it. And I found it, as a citizen of Durham as well, comforting that that was clearly what he wanted us to understand, that he wasn't going to be a district attorney who just sat behind the desk. He would be a district attorney who tried cases. Then when the lacrosse case came up, he told us in staff meeting that his decision to personally prosecute that case. It was again consistent with what he told me before, that He was the head district attorney now. It was his duty to let the people of Durham know that he was in charge, he would be taking care of this case. He was obviously going to be working on it with other people, Ms. Klein, who was the rape attorney in the office. So it was consistent with what he told us before. And then there was a quadruple homicide that came up in Durham. He planned to take that case personally himself as well. And I think that circumstances intervened to where he probably didn't have time. So I'm not sure if he ended up taking that, but he started out with it.
When he took the case, did he make, and it was close to the election, did he make any comments to you regarding taking the case in the election?
Well, he made comments to me, but never that he was taking it because of the election. It was actually comments that were the opposite. And I think that anybody who knows Mike knows that he would never do anything just to win the election, except for some election polling type things. But he would never do anything with a case to win the election.
Well, you can just speak.
Reputation for truthfulness.
This is again, you can't testify with anybody who knows. You can only testify.
This is his reputation.
You can't go to reputation.
No, not general. You cannot give general character.
What I do want is specific conversations that you had with
I'll do
Mike.
that instead. Okay.
Did you have some conversation with him about?
I did. Well, there was a number of times where it came up in larger group contexts that he would never do something specifically for the election with any kind of case. That probably came up mostly at staff meetings, but there was one specific one-on-one conversation that I had with Mike that I do recall pretty well. It was shortly after the lacrosse, what's become known as, I guess, the lacrosse case, hit the media publicity, and it was when that media frenzy was going on. And it was a few days after that. I was at actually a campaign event for Mike. It was an after work, like wine and cheese, and I stopped by, and I was talking with Mike for a little bit one-on-one. I think he came up to congratulate me because I just won a trial. And I said something to him about talking to the media because I was a little bit concerned, and he told me at that time, and I couldn't tell you the exact date, that he was no longer talking to the media. And then he said something about how a couple people had said he'd done that because of the campaign, that he'd taken the case or talked to the media because of the campaign. And we both actually chuckled about that statement. And I think it was me that said,
I would object and move to strike to what Mr. Nifong said about his motives for taking the case. This is inadmissible hearsay.
I'll let her testify.
So this has been an issue in the case as far as raised.
I'm just objecting on the grounds of hearsay.
There's been so
It's not
much-
really offered for the truth, though. It's offered that he made such a statement. And I'll allow that.
okay. I think it was me that said, this is just me quoting what I said, anybody who knows you knows that you would rather do the right thing than win the election. And I'm almost exactly certain those were my words. And he agreed. I can't remember his exact words. And then we actually discussed it for a little bit of time after that, the concept that, of course, he would never do something with a case to win the election.
Now, was there a policy in your office prior to Mike becoming the DA about whether you would pursue a case even if you did not believe it to be winnable?
Yes, absolutely. There was what was called a no-drop policy. Well, I need to back up and explain that I was when I left the office, I was the felony domestic violence prosecutor and child internet sex crimes. But in terms of the domestic violence, there was what was called a no-drop policy. And this existed in many, many DA's offices all around the country, and it had come about over years of working with victims advocates. But what it meant essentially was that we wouldn't dismiss a case, that if there was evidence that could go to a jury, it would go to a jury, as long as we were convinced of the person's guilt. And I think it's really important to make a distinction here between going forward on a case where the prosecutor's not convinced of the person's guilt and going forward on a case where the prosecutor is convinced of the person's guilt but knows that they're going to have a really hard time before a jury. That's two different things. And I'm talking about the second one. Going forward, you're convinced of the person's guilt, but you know that it's going to be hard. A lot of the evidence that you get before the jury, it's going to be really difficult. This was extremely common in domestic violence cases and sexual assault cases. But the policy of the office put in place by Jim Hardin many years ago, which I won't say, but I think was that if you could go forward, if you couldn't get a plea, you wouldn't dismiss it. You would take it to trial, that case needed to go to trial. And it was a really broad policy because it was the idea that it would affect other cases in the future. So I took a ton of cases to trial where I knew I was convinced that the person was guilty, but I knew I was not going to be able to convince the trier of fact, be it a judge or be it a jury. And most of mine were probably judge trials at that time. But it was something that I did quite regularly, and it was something that was very common in the office, not just on domestic violence cases, but many cases just have to have their day in court. They have to have their day in court. But that is different than proceeding on a case where you're not convinced.